Hey, welcome Disability Law Show, and welcome to the show. 30 minutes coming up. John Scholes here along with James Fireman on the show in just a bit. We'll get to this, the 3 bad reasons why people decide not to challenge their LTD denials. Not a good thing, and James will rip that apart in just a bit. To reach out anytime, 1-855-821-5900, the toll-free phone number. Email is help@disabilityrights.ca, and the website, disabilityrights.ca. Search there for a radio show across the country that you can tune into and catch our hour-long radio show as well. James, always start with the week that was, a success story you laid the groundwork for. What's going on this week, pal?
So I always like to talk about cases that are up for mediation or that have recently been mediated. And so this is one case where it really illustrates the significance of going through the insurance file in careful detail. And you may not understand how important it is to go through that insurance file. You might be thinking, well, it's a disability case. Isn't it really just a matter of whether or not the medical documents support that I have a disability? And certainly you need to have that, but really that's a given for me. When we're retained by someone, we're not going to start a claim unless we are already aware that the treating doctors are fully supporting that you're not able to work. So I'm not usually terribly concerned about the medical documents. They're there. That's not something that I'm concerned about. My concern is the insurance file. And the reason for that is because I want to figure out what the insurance company has done to come to the wrong decision. If your treating doctors are saying you can't work and the insurance company cuts off your benefits, then they've come to the wrong conclusion, and I want to figure out why. And so this particular client came to me, and she was suffering from what was later determined to be endometriosis. And if you're not familiar with it, it's a condition that affects, I think, about 10% of women. It's a very disabling condition. Usually it's about 2 weeks out of every 4-week cycle. And for some people, it can be completely debilitating so that they can't do anything. That was a situation for this particular client of mine. And it's particularly frustrating for the people that suffer from it because it is typically not diagnosed until 7 to 10 years. That's the average time it takes to diagnose someone with endometriosis. And so this particular client went on leave with the symptoms of what was later determined to be endometriosis, but she was cut off of her benefits. She was denied her claim by the insurance company. Now, that's wrong in and of itself because insurance policies, disability insurance policies, should be paying you if you have symptoms that are preventing you from doing your job. It does not require a diagnosis. It requires a disability, which means that you have functional limitations, symptoms, that are preventing you from being able to work. So it was a wrong decision to begin with. But when I really drilled down and took a look on exactly what the insurance company had done, there were 2 things that I discovered. The first was actually really obvious, and that was that they never hired any doctor, any medical professional to look over the file and to provide them with an opinion. And that was especially important in this case. It's something the insurance companies ought to be doing in every case. But in this particular case, had they done that, any qualified medical professional would have seen that the claims handler messed up. The claims handler indicated in the file that my client was only disabled for 2 days out of every 7, as opposed to 2 weeks out of every 4. Now, even if the claims handler was right, even if it was only 2 days out of every 7, unless those 2 days happen to coincide with the weekend every single week, which would be pretty suspicious, that's still probably going to be a disabling condition. But it was wrong anyway. It's 2 weeks out of 4. And I can't think of any occupations that you can hold where you're going to be able to say, sorry, I can't work 2 out of every 4 weeks. I just am not able to. There's really not a whole lot out there. And that is certainly something where if you're suffering from a condition that's preventing you from working 2 out of 4 weeks, you're going to be entitled to your benefits. It's as simple as that. So that was what was in the file. That's why it's so important to go through that insurance file page by page and make sure that you uncover everything the insurance company has done. And when we went to mediation, I was able to show the insurance company that this is what they had done. I was aware of it, and if it goes to court, then it's going to be in the public domain, and that's something that they really don't want. Because number one, they're certainly going to have to pay the benefits that they owe, but number 2, a judge is going to tell them that their process is unfair, that they didn't adjudicate the claim properly or fairly, and as a result, they would likely be exposed to having to pay punitive or aggravated damages. In other words, a court would order them to pay money over and above what they would have otherwise had to pay just for the benefits. That's something they want to avoid at all costs. And so we were able to get a very good settlement for this particular client.
You know, you mentioned qualifying for the benefits based on symptom, not diagnosis. How often does an insurance company get that wrong?
Well, it's a position that they typically take whenever you have something that is undiagnosable or very difficult to diagnose. In fact, I can't think of a single case where someone has suffered from a variety of symptoms, but they haven't been able to put their finger on a particular cause of the symptoms, where the insurance company hasn't taken that particular position.
Wow.
But it's also something where the Supreme Court of Canada has said very clearly the focus of the analysis is on the symptoms, not on the diagnosis. So it doesn't matter whether medical science has advanced to the point where you're able to determine specifically what this is or what we're going to call it. What matters is that you have legitimate symptoms that are preventing you from being able to work.
I can see you having to deal with this all the time when it comes to mental health. It doesn't show up on an x-ray. You know, it's not, it's nothing you get on a CAT scan, right?
Yeah, that's exactly right. You see it in mental health claims very frequently, although you do see it in claims for autoimmune diseases and other types of issues where the diagnosis is a little bit more tricky. And endometriosis is a perfect example. It's something where it's misdiagnosed or it's just missed by a lot of treating doctors to an extent where insurance companies are writing it off. They see that it's coming, when you're on a woman's cycle, and they just say, okay, well, that just must be related to their period. And so they say, we're not going to pay for that, which is obviously not a proper stance. Endometriosis is a very, very serious condition. And you needn't look far. You just search around on the internet. There have been dozens, if not hundreds, of articles written, of peer-reviewed papers written about how underrepresented, how misdiagnosed this part of the population really is.
PocketEmploymentLawyer.ca. I want to bring this website to your attention for a moment. I know it says employment on it, so and it covers every corner of employment law for sure. But there's also a section in there, and James will back me up on this, on disability law. Why is that so key? Because there's a lot of crossover between disability law and employment law. And one of James's stories also has that in it. So that's why we have it there, PocketEmploymentLawyer.ca. If you have a disability claim, if you're dealing with the insurer, you want some information, that website is also there for you as well to use anytime. But disabilitylaw.ca, disabilitylawyer.ca, that's what we're concentrating on. If you have not heard our hour-long radio show, which James does across the country, because he's awesome, you can catch those by going to the website, disabilityrights.ca. And James, we get phone calls every so often. We think, we should really play that on the TV show, because it's going to be informative for sure. So I want to get to the first call for the show from our radio show right now.
So the accident happened about 3 years ago. My wife, she slipped and fell on the winter time on some ice, private property, cracked her head. She's been off work since. For the first year after it happened, she couldn't even look at any bright light. And the lawyer that she had basically came to her and said, look, I'm going to be leaving the firm. I want to kind of settle house 6 months worth of pay, and that's that.
See, this is one of those cases where, again, the employer and the workplace and disability all goes along with it. And I know you're going to want to talk about the slip and fall where it happened as well. But again, a phone call from our radio show, disabilityrights.ca. If you want to catch a station that you can tune in on a weekly basis, several times a week, as a matter of fact. What do you say, James?
Well, so this is a pretty tricky situation. And I hesitate to be overly critical without knowing all of the facts and why this particular lawyer recommended a certain settlement, 6 months or whatever it was. I don't know enough to really say that that was inappropriate, but it certainly sounds, by the way this caller is presenting it, that it was, the lawyer was leaving and he was just trying to wrap things up pretty quickly, and perhaps it was not in the best interest of this particular client. So one thing that you can certainly always do is seek a second opinion, and we're always happy to do that. There's never a charge for that. And I can tell you that when people come to me for a second opinion, I'm not looking to have people move over to my firm if they're represented by lawyers that are serving their interests, because if you move from one firm to another, and you are already represented by someone competent, all that's going to do is increase the legal fees that you're going to have to pay. You're going to have to pay your previous lawyer, and you're going to have to pay your new lawyer. But you should also have confidence in the legal advice that you're being given. So a few things you can do. First of all, if you're concerned that the legal advice that you're getting isn't in your best interest, approach your lawyer and ask for a full explanation of exactly why they are suggesting what they're suggesting. A lawyer's job is first and foremost to give legal advice and to communicate that to their clients in a clear way that they're able to understand and process, so that the client can provide the lawyer with instructions. That's the way the relationship is supposed to work. The lawyer provides advice, the client gives instructions. And if the lawyer hasn't given clear enough advice, the client can't do that. So go to your lawyer first and foremost and make sure that you understand why they are suggesting this might be a reasonable solution for you. If after having done that, you're still not satisfied that the lawyer's advice is in your best interest, then it's always worthwhile to seek a second opinion. And again, we're happy to do that. We don't charge for that. And I'm not going to suggest you move firms unless it's going to be in your best interest to do it. Now, this caller did talk about the situation was a slip and fall.
Yep.
And so it's always important to remember whether it's a slip and fall or a trip and fall as the weather starts to get a little bit better and people aren't tripping on, or slipping on ice anymore. It's always important that you get some evidence about how the accident happened. In an ideal world, if you have your smartphone with you, take it out and take some pictures. Make sure that you see if you slipped on ice. Make sure you get photographs of the ice before someone comes out and pours a whole bag of salt on it. But if you trip over a ledge or a sidewalk that has a big divot in it or a pothole or whatever, try and get a photograph of that particular evidence as well too. Try and get it so that you can see the discrepancy. If there are two slabs of sidewalk and they're uneven, you want to make sure that you have a photograph that can clearly show the discrepancy. Now you might be asking, well, how do I do that if I've just slipped and fallen, maybe broken your leg, or you're in a considerable amount of distress? If you don't have the wherewithal to do it at the time, then make sure as soon as you think of it to ask someone to go back and get that evidence, to take photographs of that particular area. Because it's going to be critical down the road to make sure that when you bring a claim, if you decide to bring a claim, that you're going to be able to prove that the situation resulted because of someone else's negligence. Whether it's private property or municipal property, you want to make sure that you have that evidence and that you have it secured before too much time passes. If you get it a year or 2 years down the road, there's nothing to say that that's how the situation was at the time of the accident. And more than likely, a court is going to find that the other party isn't liable, that you can't prove that they were negligent because it's out of date. So please make sure you get that evidence in a timely fashion.
All right, coming up after a short break here, we will get to this: 3 bad reasons why people choose not to challenge their LTD denial. We'll get to that after a short break. 1-855-821-5900, the phone number, and help at disabilityrights.ca. People think you have to sign back a severance offer by a deadline. Employmentlawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at employmentlawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think contractors aren't owed severance. Employmentlawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at employmentlawyer.ca. All right, thanks for hanging around and welcome back. Disability Law Show. John Scholes here along with James Fireman this week. Again, want to get to this: 3 bad reasons why people choose not to challenge their LTD denial. Number 1 is this we talk about all the time, and that is fear, or at least the perceived imbalance of power with the insurer. Right, James?
Well, it's funny because that's exactly wrong. There is a huge imbalance of power both before and after a legal claim, but it flips. Before you start a legal claim, the imbalance is in favor of the insurance company.
Yep.
They're a huge multi-million or billion-dollar company. All they do is deal with insurance. They have people dedicated to dealing with disability insurance. They have all the resources in the world, and you're trying to take them on by yourself. That is obviously a huge imbalance. And adding to that, the insurance company really gets to make up the rules. Yes, there is a policy that dictates how the policy is supposed to work, but there's no one who is enforcing that. There's no one who's looking over the insurer's shoulder and making sure that they play by those rules. And if you decide to take them up on an offer to appeal when you've been denied or cut off, and please don't, but if you do, they're making up the entire process themselves. So there is a huge imbalance up until the point when you start a legal claim. As soon as you start a legal claim, though, everything changes. The insurance company is now not in charge of making the rules. That's going to be set by the judicial system. So they have to play by the rules of the court, and they have to follow the legal process. They have to play along, and if they don't, they're going to be in front of a judge really quickly, which means they know they have to act reasonably because they don't want to be in front of a judge, especially when I can say, look how they've acted, look what they've been doing. So that's the last thing that they want. The other big difference is that where there's an imbalance before, where the insurance company has all of these resources and you're trying to deal with them on your own, that is also very different afterwards, because once you start a legal claim, it moves from the claims department to the legal department in the insurance company. And the legal department's going to assign it to a lawyer there. And their lawyers there are perfectly competent. Some of them are excellent lawyers, but they're way overworked. They have far too many files. They don't have nearly the amount of time to dedicate to your file or any other file in order to really understand what's going on. Certainly not nearly the time that I'm able to dedicate to each file that I take to mediation. Anyone who retains me is going to get me to go through that entire file very thoroughly in a way that the insurers simply can't afford to do it. So yeah, there's also an imbalance after you start the claim, but now the imbalance is in your favor. So if you're concerned that you don't want to start a legal claim because of the power imbalance, that's exactly wrong. You should start the legal claim to get the power imbalance in your favor.
We were talking about the 3 reasons people choose not to challenge their LTD denials. Number 2 is this one, and it is a false hope that maybe, kind of, sort of, the insurance company will approve their appeal or appeals. You can pluralize that, no problem.
Yeah, there it is. So when you get denied or you cut off your benefits, your insurance company is going to send you a letter.
Yep.
And in that letter, they're going to set out the reasons why they've come to their decision. Often it's going to be very vague. Sometimes they'll give you some detail. But after they've torn your heart out, they're going to put at the bottom of this letter an invitation. It'll be a heading that says, appealing the decision. And it'll tell you how you can write to the insurance company to appeal their denial of your benefits. And most people see that and they think, oh, okay, well, it's bad now, but if they just see the light, if they just understand, then they'll surely pay my benefits. And again, the insurance company is making up this process. They are determined. If you look in your policy, it's not going to tell you how the appeal works. In fact, it's not even going to refer to the appeal at all. The appeal is something the insurance company has made up. And the reason they do this is because they want you to stay within their game. They're making up the rules on the appeal. They want you staying there. If you start a legal claim, all of a sudden they don't get to make up the rules anymore. So they don't want any part of that. And so the appeal is just a mechanism that they use to make sure that you don't go call a lawyer, that you don't start a legal claim. It's a waste of time, and all it's going to do is it's going to delay your resolution of your claim. It's going to delay getting the benefits that you're entitled to.
And it's not always just one appeal, is it? They can go on several times.
No, most insurance companies are more than happy to give you 2, 3, 4 appeals. I had a client recently that, I swear to you, appealed 7 times.
Come on.
Now, the amazing thing is they were able to do those 7 appeals and still get to me within time to bring the claim. You only have 2 years to start a legal claim after your decision is first denied. And so they were able to appeal 7 times within those 2 years and still get to me in time to start a legal claim. And they got a very good result at the end of the day.
Number 3, third reason why people choose not to challenge their LTD denial. Is this a general mistrust in the legal system and lawyers? What?
Well, listen, I have to acknowledge that there is a widespread mistrust of lawyers, and I wish it weren't so, and I do everything that I can, and the lawyers at my firm, we do everything that we can to try and reverse that. We're on the show, we're giving out information for free, we're not charging anything for this information. We have radio shows where people call us and ask us for advice, and more to the point, if you don't want to be part of that process, but you just want to get the advice, I invite people all the time to call for a free consultation. And so if you're watching and you have a question or you have a potential claim, give us a call. It's 100% free. No one's going to ask you for your credit card number. You can call us, get the advice, decide what you want to do with it. And so, that's something that we do everything that we can to try and change the way the public perceives lawyers. But here's the good news. The way that our retainer works, and the retainer is the contract between our clients and the firm, the way our retainer works is it really ensures that our client's interests and our interests are perfectly aligned. It's called a contingency fee agreement. And so what that means is that we do not get paid. My firm does not get paid for anything that we do unless the insurance company pays money, and we don't receive that payment until the insurance company pays that, which means two things. It means that you will always know that we are out to get as much as we can from the insurance company, and we want to get it as soon as we can. As much as we can, as soon as we can. I've never had a single client that didn't have those two interests. And so our interests are perfectly aligned by the contingency fee agreement. And a contingency fee agreement, that's not unique to my firm. That is something that any firm that's practicing in disability law, any experienced firm practicing disability law, is going to offer their clients, and it's for a good reason. Because if you have a potential disability claim, it means that you're not working, and it means that you're not getting benefits from your insurance company. So you surely cannot afford to pay a lawyer $300 or $400 an hour and give them a $10,000 retainer at the outset in order to take your file. If you have a lawyer that you're approaching for a disability claim and they're asking you to pay an upfront retainer, you can believe that they probably do not have significant experience dealing with disability law.
Coming up here, refusing to go to the insurer's recommended treatment, and you are cut off your benefits. We'll get to that after a short break. The number James just talked about, 1-855-821-5900. Email as well, help@disabilityrights.ca. We'll be right back. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Thanks for hanging in. Disability Law Show. I'll give you another place you can go anytime to ask James or one of his colleagues a question, mydisabilityquestions.com. We always get to them on the show. We always read them and get an answer for you. This one right now, James, is from Valerie. Valerie says, if you are declined disability benefits multiple times and have already appealed, what happens next? Do you have any other options?
Well, what happens next is really going to be up to you, Valerie. You can keep appealing and go on that treadmill and appeal like with the client I talked about a few minutes ago before the break that appealed 6 or 7 times, or you can cut to the chase and start a legal claim. That is your other option, and that is going to be your best option. And I've said it, I think, probably 3 times on this show already, but it's worth repeating again. Once you start the legal claim, the power imbalance stops and it starts shifting towards you. The insurance company is no longer able to make up the rules. So why people continue to appeal, I don't understand. If you have new information, perhaps that's a different story. But if your claim is substantially the same, if the medical information has not changed, do not waste your time with another appeal. Start your legal claim. The sooner you start it, the sooner you get the benefits that you're entitled to.
Want to get to an email now, help@disabilityrights.ca is the way you contact James and the firm in that regard. This one from Angela. Angela says, my insurer sent me for an assessment and their doctor recommended different medication. Both my GP and specialists say the medications recommended by the insurance company doctors are narcotics, are highly addictive, and have serious side effects. I'm following my doctor's advice and staying with the medications they recommend. In response, my adjuster announced that my benefits are being cut off because I'm not complying. Can they do this?
Hard no. No, they can't do that. Now, when I say they can't do that, what I mean is they're not entitled to do that under the policy.
Right.
But until you bring a legal claim, they can do whatever they want, and there's no one to force them to do the right thing. But they are not entitled to get between what is your proper treatment and what your doctors are telling you should be doing. They're not allowed to do that. If your doctors are telling you that you should not be taking narcotics, that narcotics are the wrong solution for your particular disability, you have to listen to your own treating doctors. They have your best interests at heart, and you better believe that a doctor paid for by the insurance company on your claim does not have that same interest. That doctor has an insurance company that is paying their bills at the end of the day, and they want to make sure that they continue to get more work from that insurance company. So you better believe that that doctor is trying to make sure that that insurance company has been served properly. So please do not take the advice of the insurance company over your treating doctors. And in a situation like that, when an insurance company has gotten in between treating doctors' recommendations and the actual proper treatment for a particular claimant, and they've suggested that they start taking narcotics, which are, of course, addictive, and they have significant and serious side effects that you have to deal with, the benefit there is really only going to be short-term. The long-term impact is obviously going to be much worse for the claimant in that type of situation. So the interest of the insurance company is pretty obvious. It seems pretty clear that the insurance company is really just trying to find a very quick fix so that they can say, oh, look, you're taking the narcotics, all of a sudden you're feeling better, it doesn't hurt you anymore, you're okay to get back to work. But they're not allowed to do that. They're not allowed to sacrifice your long-term health for their benefit. And if your doctors, again, if your doctors are telling you not to do it, listen to your doctors. When an insurance company acts that way, it really exposes them to significant punitive damages. So that means a court, if this ever went in front of a judge would look at this and they would be horrified. They would be absolutely horrified to see an insurance company insist that you go get narcotic medication in order to treat something when your treating doctors are telling you not to do it. They're going to punish that company by making them pay punitive damages, and it might be a significant amount, perhaps enough that it might even dwarf what you might be owed just for the benefits on their own.
I noticed Angela said right at the top of that email as well, she was sent for an assessment. That doesn't always happen. Sometimes isn't it just a paper filing that the insurance company will depend on and then make medical advice upon that?
Yeah, in this particular case, the fact that they actually sent her for an assessment, there's nothing inappropriate about that.
Right.
And in fact, I think that's actually best practices. I think insurance companies more often should be sending people for an assessment. When their doctors just look at a claim and all they see is the paper on the file, there's always a lot of questions that aren't answered, things that they might be able to get answered if they had that person sitting in the room with them. And so it's usually a deficiency that I'm going to jump on. In this particular case, they've gone for the assessment, but the solution here being suggested by the assessing doctor really is incomprehensible. I mean, how they can be saying that she should be taking narcotic medication when it's something that her doctors have clearly told her not to do is beyond me. And that type of exposure is really significant. Insurance companies want no part of that. And so if you start a legal claim in this scenario, what's going to happen, it's going to land on the desk of a lawyer for the insurance company who's going to look at it with fresh eyes. And they're going to see this right away. They're going to see that the insurance doctor has told them that they have to get narcotics, and the claims handler has run with that and cut off the claim because you haven't followed through with that recommendation because you've listened to your doctors, hopefully. And as a result, that lawyer is going to know that they're in big trouble, which means they're going to come to the table and they're going to be more than reasonable. They're going to pay a significant amount to avoid that ever going anywhere close to a courthouse.
Which is interesting because a person's reaction listening to this would say, oh, it goes to one of the lawyers. Now I'm even more scared. No, that's better because now you got someone like you who understands this whole process, who wants to wrap this up.
Yeah, it's really one of the things that people misunderstand about the legal process. They assume that they're going to be dealing with the same jokers that have been handling their file up until that point in time, but it's quite the opposite. As soon as you file a legal claim, what happens is it moves from the claims department at the insurance company to the legal department. And there's a new claims handler in the legal department, and there's a lawyer assigned, and those people have never touched your file before. And typically speaking, they are far more competent, and they understand what they have to do, and they understand how the adjudication has gone wrong. So they're going to be in a much better position to act reasonably and come to the table and pay what you're entitled to.
Lots of good stuff every 30 minutes on this show. You'll want to reach out now that we're just about to wrap it up. I'll give you the phone number, 1-855-821-5900. help@disabilityrights.ca is the email address we always use. You can use that as well. And I mentioned mydisabilityquestions.com. That is a searchable database as well, so you can look for your question before you send it. And if it's not there, leave it. James and the guys will get to it. Catch you next time, Disability Law Show.